Good evening, everybody. My name is Barbara Comstock, and I'm on the board of the Southwest Harbor Public Library. It's so nice to see all of you joining tonight. Thank you for coming. Throughout January and February, the Southwest Harbor Library is hosting many thought-provoking talks. On January 27th, Celia Torti, College of the Atlantic's president, will provide her experiences and reflections from a one-time tropical field biologist. On February 10th, Zach Heiler, an ocean educator and whale watch naturalist who participated in whale research and ecotourism in the North Atlantic, will be presenting a talk about a marine life sanctuary. Further information on these and other talks are available on our library website, and we hope you can join us. This evening, it is my pleasure to welcome you to Separation of Powers, its birth, life, and modern demise with Judge Richard Cohen. Richard Cohen, a graduate of Princeton University and the Yale Law School, is a retired judge who served on New Jersey's Superior Court Appellate Division. He was a trial judge for 10 years and an appellate judge for 11, during which time he authored 148 opinions published in the official court reports. After retiring from the bench in 1994, he conducted a mediation and arbitration practice until 2017, when he moved permanently to Mount Desert Island with his wife, Pamela Hattem. He has taught 7 Acadia Senior College courses on various topics in constitutional law and history. Tonight, we're recording tonight's program. Erich will help facilitate the online audience questions at the end of the talk. Zoom participants, please use the chat feature. Please warmly welcome Rick Cohen.
Thanks, Barbara. I may seem to be bobbing up and down a little today. I'm going to start standing up. I'm not sure I can do that very long. My back is killing me. So if I kind of sink out of sight a little bit and then come back up, it's okay. I'm doing it. All right. It's January 20th again. We just finished a shocking year, and I think we're about to enter another one. We have a president who's unbalanced and impulsive. He's a schoolyard bully with a masked private army and a dangerous national and international agenda. He's a dishonest grifter without ethics or empathy or understanding. His impact at home and abroad has been disastrous. On top of that, and not attributable to him, American prosperity is no longer widely shared as it used to be. We are the most unbalanced Western nation in that regard. We still generate great wealth in our economy, but we distribute it in a manner that is grotesquely unfair. Example. I read that just this morning in the Economic Policy Institute website that from 1978 to 2023, American CEO compensation increased 1,085%, compared with a 24% increase in typical workers' compensation. In 2023, CEOs were paid 290 times as much as the typical worker. In contrast, to 1965, when they were paid 21 times as much as a typical worker. So if you have a company and the average wage of the employees is $100,000, which is pretty good, the CEO is making $29 million. If your workforce is only making an average of $50,000, the poor CEO is cut way down to $14.5 million. That's grotesque. No other Western country permits that sort of thing, and it's easily preventable with a simple IRS provision that says you can deduct corporation CEO salary up to % or up to a number of dollars. Easiest thing in the world, never get done. With all of the governmental and economic problems we're having, why do I want to spend time nitpicking over the details of governmental structures? Because someday Trump is going to be gone and his impact will fade, and the job of putting Humpty Dumpty back together again is going to fall to our children and our grandchildren. And it'll help them to know what traditional institutions didn't work very well. An important one of them is the separation of powers and checks and balances. And it's for that reason that it's our topic today. Separation of governmental powers was not a new idea in 1787. It wasn't even an American idea. We're really talking about two different things. There's the functional distribution of governmental activity that naturally falls into three different baskets. Legislation translates public policy into law. The executive applies it to the everyday life of the community. And the judiciary provides a forum for the resolution of disputes between people and the government, and helps enforce the law. As to the, the other thing we're talking about is the purposeful creation of mechanisms within governmental branches that will serve to permit them to defend their own authority and to control the powers of the other branches. As to the first, that natural distribution of functions into three baskets has been going on for millennia. Rome is a great example. The Roman Republic had a Senate. It had two consuls, except during emergency times, the Senate elected a dictator. There were courts, and there were many, many years of stable government, but not sufficiently stable to fend off authoritarian takeovers. Since at least the 13th century, England has had versions of the separation of powers. Magna Carta was signed by King John in 1215. It grants authority to 25 barons chosen by their... Is there something that happens with my sound? Can you hear it? When I lean over it, is it okay if I stand up? No problem. Okay. It's an odd device here. Yeah. Yes. The Magna Carta grants authority to all of the barons to choose 25 of them.
You want to use this one instead?
Well, I know, I'd rather not.
Okay.
And the 25 barons have authority to, quote, keep and cause to be observed with all their might the peace and liberties granted and confirmed to them by this charter. Further gives the 25 barons the authority to restore property and liberty to any man deprived of them, quote, without the lawful judgment of his equals, unless he was deprived by King John's father, King Henry, or his brother, King Richard. And that it specifically says, can't touch that. Over time, England had what looked more and more like a three-branch government: a monarch, a bicameral parliament, and two court systems. Although Parliament had varying budgetary authority, the monarch dominated. He chose the members of the House of Lords, and he conferred noble status, accompanied by income-producing estates. For much of English history, he could also take them away. And by the way, he was immune from criminal prosecution. The House of Commons was elected by a small upper crust portion of the population. In addition, many members of Parliament of the House of Commons were given salaried governmental positions by which they made their livings. And those jobs could be withdrawn by the king at any time and for any reason, which seemed somehow to discourage opposition to the king's policies. Incidentally, our Constitution prohibits any member of Congress to simultaneously hold any other governmental office for that reason. The king appointed all the judges, and he could discharge them without cause. And that arrangement defeated the hope that the judges would be independent. All in all, the separation of powers in English history was not designed to achieve independence of the branches of government. As the great American political philosopher Mel Brooks put it, it's good to be the king. The English pattern was not followed in the Articles of Confederation that were approved in 1777. From then till 1789, when the Constitution was adopted, we had a one-branch national government consisting of Congress, period. That was it. There was no federal court system at all. There was an official called the president, but that meant that he presided over sessions of Congress, and he had minor administrative responsibilities when Congress was not in session. It was a primitive and toothless government whose only job was to do a few things that required national consistency. And it could do those few things only if it had, as to each item, the approval of at least 9 of the 13 states. Most authority remained in the state governments, which, unlike the new national government, were trusted and familiar. It soon became apparent that the simple government created by the Articles wouldn't do. National government had to have jurisdiction over military affairs, foreign relations, and interstate and foreign commerce, and had to be able to impose taxes rather than send invoices to the states, which often remained unpaid. We needed an executive department to carry out the policies adopted by Congress, and it was Congress that the founders expected to be the strongest branch. And we needed a federal judiciary which would protect national interests and not favor locals over people from away. Not everybody was on board with this. The Jeffersonians thought America was going to be a simple agricultural society in which a small national government was going to play a minor role. The Federalists, however, predicted a growing, complex economy that needed a growing and complex government for both support and control. But a runaway national government was still regarded as a threat to the sovereignty of the states and the liberties of the people. So the framers of the Constitution found a solution in the writings of John Locke and Charles, the Duke of Montesquieu. They both argued for the division of power, and Montesquieu's insights were the most persuasive. He said, quote, the legislative and executive powers are united in the same person or in the same body of magistrates. There can be no liberty, end quote. And he added, quote, there's no liberty if the judicial power be not separated from the legislative and executive. His most significant contribution was his argument that each separate branch should be expected to defend and firm up its own authority, that the power ambitions of each branch would confine the others and hold them in check, and that structural safeguards should be created to enable each branch to confront the others and control their ambitions, because the personal virtue of governmental officials was not something to count. James Madison got it. He understood. He was always the smartest kid in the class all his life, and was the most important voice in Philadelphia. If men were angels, he said, no government would be necessary. In framing a government which is to be administered by men over men, the great difficulty is this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. So, the president is the military commander in chief, but only the Congress can appropriate funds for the military or declare war. And the president nominates federal officials, but Congress can deny them confirmation and impeach many of them. Only the Congress can enact laws, create and fund programs and agencies to carry them out, and impose taxes to create the necessary revenues. And the president is required by the Constitution to, quote, take care that the laws be faithfully executed. However, the president can veto legislation, then a supermajority of the Congress can override its veto. The Congress can impeach and dismiss members of the executive and judicial branches. The judiciary can declare legislation unconstitutional, but the president appoints the judges and justices with the advice and consent of the Senate. The Congress has the expressed, but so far untested, constitutional power to define and limit the jurisdiction of the federal courts, and has the authority to propose constitutional amendments for ratification by the states. So that was the design. How's it worked? Fairly well for many years, but no longer. I want to explore the reasons for its failure and the consequences. The legislative and judicial branches have not exercised and defended the powers the framers of the Constitution gave them, and have not performed their essential work of controlling the power of the executive branch. There are three important reasons for this failure, and as soon as I sit down, I will tell you what they are. Ever knew that sitting down was so difficult. Okay. First, of the three reasons. The framers badly mistook the way the future government was going to get its work done. Second, Congress has become dysfunctional as a result of the filibuster and excess partisanship, much of which I attribute to gerrymandering. Third, the Supreme Court has abandoned its authority to place necessary constitutional limits on the presidency. Let's take a look at those. First, the national government today is conducted mostly by agencies, some called independent agencies, some called just agencies, some called departments. If the White House burned down tomorrow and Congress voted to disband, the federal government could continue to function without them for a very long time. The work that gets done is not done day to day by the White House and the Congress. It's not a surprise. We live with that, assuming that that's the way things are. But the framers did not predict what future government would require, and the Constitution, therefore, totally ignores the subject. The problem is essentially, where do these agencies belong in the tripartite government? It's really hard to say. When Congress creates an agency to do a job, like protect the environment, how freely can it permit the agency to decide how best to do it? Is that something only the Congress can do? Or can the agency itself be empowered to fill in the details? Or can the White House define the job and limit it or expand it? Are the agency's goals and means of reaching them controlled by the enabling legislation, or the executive, or the agencies themselves? Who can fire the agency heads, and for what reasons? Who controls their budgets? Are they subject to executive orders? Can the White House give them jobs Congress didn't give them? Or shut down an agency completely? Does the Constitution create a unitary executive that dominates the government? Don't sit there expecting answers to those questions. I know 9 guys who wear black robes every day who don't know the answers, but have the job of making them up. When the president and the Congress and the agencies agree on policy, leadership, and on activities, there's no problem. Franklin Roosevelt had an enthusiastic Congress, committed agency staffs, and eventually a compliant Supreme Court. But if you elect a headstrong president with a loyal Congress, both of whom oppose the work the agencies are doing, you have conflicts that are very difficult to resolve. By and large, a liberal president, Congress, and court will encourage agency activism and independence in pursuit of their goals. A conservative president, Congress, and court will want to rein them in. Is that a technical legal dispute? It may sound like one, but it really is not. It's a policy outcome that counts, even for the Supreme Court. The Supreme Court has consistently moved control of the agencies, their powers, their heads, and their activities from Congress, which created and defined them, to the White House. It's not a coincidence that today, most of the work of the agencies is prized by the left and opposed by the right. What about Congress? In recent years, Congress has been a legislative wasteland where nothing grows. The House of Representatives has become a wrestling ring where the members' only goal is to pin the other side to the mat. Legislating is not much of a concern. The Senate is disabled by its filibuster rule. There's a lot to recommend requiring 60 votes to enact anything in the Senate. But in times like today, of extreme partisanship and almost equal membership, it can prevent getting anything worthwhile done. Gerrymandering in the House has a greater, stronger, and more dysfunctional effect. Let me say why. Each state government periodically divides the state into a number of districts equal to the number of House members it's entitled to. The districts are supposed to be geographically compact, but rarely are. They're supposed to avoid dividing municipalities and neighborhoods, and sometimes do. Basic notions of fairness require that they grant each voter a vote of roughly equal weight, and that they rarely do. The reason is that one political party controls the state legislature and thus the redistricting, and can divide the state into districts that will favor that party. Used to be that it was an imprecise and intuitive process that involved lots of head scratching. But now there are software programs that can turn out hundreds of inviting district plans almost instantaneously. And the state's ruling party can choose among them with mathematical precision to unfairly diminish the minority party's power in electing the congressional delegation. I do not disrespect you by laying that out. I know you know all that. But here's the punchline. The effect of gerrymandering is to create a pattern of safe congressional districts that strongly favor incumbents. If you succeed in creating districts that will elect your candidates, those districts will probably remain yours and will continue electing your candidates for a long time. And for the same reason, the few districts you leave for the opposing party will also remain theirs for a long time. The result is that the general election becomes almost meaningless for both parties, because the safe districts that have been created dependably elect the candidates the parties have nominated. This isn't the only possible outcome, and incumbents can be defeated, but it's the usual and expectable result of creating safe districts. So the election that counts is the primary. A party's candidates are chosen by the party, and their campaigns are influenced by the party, financed by the party, and its adherents. The candidates need to show party loyalty in order to avoid competition for the nomination. Independence from partisan policies and willingness to reach across the aisle to achieve centrist goals may be valued by voters, but they're certainly not valued by the party organizations. The danger of being primaried from the extreme end of the party is a constant threat, and it's best avoided by adopting the party's more extreme policies, and avoiding centrism like the plague. Bipartisan is a dirty word, and representatives have adversaries, opponents, not colleagues. That gives us a pretty good segue into the failures of the Supreme Court to perform its duties. Partisan gerrymandering defeats the goal of equally weighted votes. At the very least, it deprives voters of the equal protection of the laws. And yet, the Supreme Court in 2019 in the Rucho case denied that a certain level of political support in a state entitles a party to a commensurate level of political power and influence. Such a claim sounded to the majority like a claim for proportional representation, which it was not. They held that the Constitution does not require it, that federal courts are neither equipped nor authorized by the Constitution to apportion political power. The most important point, I think, to the court was that federal courts could not come up with a standard by which to determine how much gerrymandering is too much. A little bit, let it go. It's really unfair, gotta stop it. Where's the line? They've never been able to figure that out. The majority of the court, because obviously the court was split, admitted that excessive partisanship leads to results that seem unjust. They said they do not condone partisanship, but they did say that there was a remedy. They said that Congress has the constitutional right to prevent it, which is true, and that the states themselves could individually do so, which is also true. But it sounds to me much like the reassuring thought that since polluters always have the option to stop fouling the air and the water, courts need not concern themselves about it. It's nonsense. The Constitution is a fraud if it does not entitle us each to equal voting weight. Anything else is unequal protection of the laws. Deciding how much gerrymandering is okay and how much is illegal is really hard. And the current court is not the first one to say so. Doing it with precision is impossible, but that's not required. Courts have to rule every day in every case, well, not every case, lots of cases, on where to draw the line across a continuum to divide what's okay from what's not okay. Examples. How unequal do the populations of congressional districts have to be invalid? How unreasonable does a search and seizure have to be to violate the Fourth Amendment? How cruel and unusual does a punishment have to be to violate the Eighth Amendment? How necessary and proper does the law have to be within Congress's powers? How speedy and public does a criminal trial have to be to satisfy the rights of a defendant under the Sixth Amendment? How much market dominance triggers the antitrust laws and how little doesn't? How loud does tavern music have to be to permit a town to limit it? How many cruise boat passengers are too many for a town to accommodate? Answering every one of these questions is hard and necessary and gets done. In the last few years, state Supreme Courts have invalidated gerrymandered district maps in Pennsylvania, North Carolina, Ohio, New York, Alaska, and Wisconsin. State trial courts have done so in Maryland and Utah. All these courts have found supporting constitutional provisions in their state constitutions, which are very similar to the US Constitution, and a number of them are identical. 5 state Supreme Courts have agreed with the US Supreme Court that courts can't invalidate partisan gerrymandering laws. Strangely enough, they're all in states where the GOP controls the legislature: Kansas, New Hampshire, Nevada, Missouri, and South Carolina. There's something that's gone very wrong when a court says it has no authority to forbid a plainly improper practice, one that distorts election results by making some votes count more than others. It's especially so when it's the Supreme Court that says so, despite the state courts taking on that responsibility. It's almost as excusable as deciding that the president is not indictable for acts anyone else can be convicted for if the president was acting as president. If ordering the killing of ocean boatmen you think are carrying drugs is an immune presidential act, how about ordering the military to destroy any truck on a US road that seems to be carrying drugs, killing everybody in the truck? Maybe a second rocket will be necessary if the first one doesn't get everyone. The presidential immunity decision ignores the reasons that we were not thrilled with King George III and our eagerness to get out from under an uncontrollable monarch and set up a government where dictatorial behavior would not occur. The immunity decision has no textual basis in the Constitution whatever. It has no connection to our history, no connection to the framers' intentions, and no basis in current public policy. The majority opinion expresses concern that a president who is subject to indictment will be afraid to take decisive action for the country for fear of political prosecution. It's a fear that President Trump has often expressed, but no president before him has ever said or believed, as far as we know, that a president could act criminally without consequences, or has refrained from taking action because he feared indictment. Only Trump fears indictment. Could be before he likes the idea of indicted people he dislikes, or because he wonders, as no president before him has had to do, whether his actions are criminal. The immunity decision is very wrong and would have been wrong at any time in our history. But to make the decision in 2024, just before the re-election of Donald Trump, is inexplicable. Just as in the gerrymandering decision, it rejects the authority the court has and has a duty to exercise. Political parties can distort election outcomes without fear of judicial correction, and presidents can conduct their presidencies by committing what for anyone else would be crimes. What else? The Voting Rights Act of 1965 was probably the most important statute of the century. Section 2 prohibits any voting practice or procedure that discriminates according to race or color. The Supreme Court is about to decide a case called Louisiana against Callis. I don't know how to pronounce it, Callais, and is likely to rule that protecting the rights of Black voters as a group against racial gerrymandering under Section 2 is unconstitutional. You hear that? That protecting the rights of Black voters, who we know for decade after decade after decade were kept off the voting rolls, were physically kept out of the voting booth. It's unconstitutional to protect their voting rights. That's an odd constitution. In 2013, the Supreme Court ruled in Shelby County against Holder that the pre-clearance requirement of Section 5 of the Act was unconstitutional because the list of, let me stop. Do you know what the pre-clearance requirement is? Oh, I'm getting a few yeses and a few nos. Okay, the section, I don't know, there's 4 and 5 work together. I forget which is which. The point is that Congress identified jurisdictions, not only states, but some counties and cities around the country, who had a history of discriminating against minority voters. And the test that you had to pass in order to avoid that list of discriminating jurisdictions was whether or not more than 50% of your eligible voter population registered. If they did, you were home free home. If they didn't, there was a good chance, according to Congress, that people were being kept away. A rough and tumble kind of standard, but it turned out when you see the list of the jurisdictions that were made subject to pre-clearance, that it worked out pretty well. Not totally the South, majority the South, but not completely. So if you're on the list of the bad guys, before you make any change in your voting legislation or regulations, you have to clear it either with the US Attorney General, who has the power under the statute to say, no, you can't do that. Or alternatively, you can go to a special US District Court in Washington for a declaration one way or the other. Okay? Under the statute, Congress was supposed to review that list every 5 years, so that if anybody fell under the standard that didn't before, they could be added to the list. And any jurisdiction that had behaved itself really well could get off the list and didn't have to come for pre-clearance. So Congress, like a lot of other things, didn't do it. I'm not sure why, but they didn't. And in 2013, a lot of the states subject to the pre-clearance requirement came to court and said, hey, no, they're not doing their part. We're being the good guys. We've changed our behavior, which in some cases was true. So let us off the hook. The Supreme Court decided that Congress had failed to perform a necessary function, and that as a result, this list which hadn't been updated, I think, since roughly 1980, something like that. Unconstitutionally discriminated between the states and rendered some of them liable to for preclearance. So they invalidated the whole program. It was the wrong thing to do. They were right that Congress had screwed up. They were right that jurisdictions that had behaved themselves since 1980 had a claim to being let off the hook for that reason. But they didn't have to do it the way they did it. Imposing the remedy of statutory invalidation went too far. All they had to do was to say, this is no good. Congress has failed in its authority. We can't let this go on. This decision will take effect in 90 days. And in 90 days, Congress, you can decide whether or not you're going to update the list. And in 90 days, jurisdictions, you can apply to Congress and let them know what good guys you've been and get off the list. One of the most important parts of a court's job is to devise an appropriate remedy for the wrong. Not every statutory screw-up is a capital offense. The remedies are a wonderful subject in the law. And on this subject, the majority of the Supreme Court is really guilty of just plain bad lawyering. Unless that's what they wanted to do. I don't know. There were 6 of them and there were 6 different people making the same conclusion, but they may have arrived at it in different ways. I don't know. It's very discouraging. What's the reason we should what's the lesson we should take from all this? Separation of powers without effective checks and balances, enforced alertly and actively by each branch against the others, simply doesn't work to restrain the power ambitions of one branch of government. We know that because we're living through it. Congress and the Supreme Court didn't invent Donald Trump, but they have both failed in their duty to restrain him. It's all going to be better someday. How do we do questions? Oh, you guys. Anybody? Yes.
How will it get better? How will it get better?
How will it get better?
Sorry.
I'm not sure. I'm not sure it will. A lot of us, I'm older than most of you, maybe all of you. But some of the rest of you grew up in the years during and following the Second World War, when we all knew we were living in a country whose virtues were unique, extraordinary, generous, empathetic, peaceful. And I mean, it was all wartime propaganda. Some of it was true. But it was sold to us, with a shovel. And we grew up that way. And after the war, in the late 40s and 50s, the economy was doing wonderfully well. Distribution of its benefits was much better than it is today. And everything was terrific. I think it's not unreasonable to hope that that vision of ourselves survives enough so that eventually we're all going to stand up and get rid of this situation. How we're going to do it, I don't know. I mean, I fear sometimes that Stephen Miller and Russell Vogt are co-presidents. Don't intend to have a 2026 election. It's a real, maybe. Anyway, the answer to your question is, I hope, but it's up to us, and it's not going to happen if we're spectators. It definitely is not going to happen if we want somebody else to take care of it.
And online question, which is so similar, is there any way to stop Trump other than his own morality in mind, other than Republicans finding their voice?
Other than,
Republicans finding their voice. So if Republicans don't find their voice.
oh, find their voice. They've got a voice. It says, oh, please, oh, please. Well, I guess it's the same question, really, and it's the same answer.
Yeah.
We have to be active. I mean, I started, my favorite phrase starting in February was courts and crowds. If we can't count on courts and crowds, we're not going to do it. Every Saturday from 11 to 12 across the street. Courageous lower federal court judges who have really been good. Not 100%, but much closer to it than I would have expected. How the Supreme Court can look at itself in the mirror when it knows that the lower courts are getting it right, I don't know. I think that the only thing that Trump eventually is going to have going for him is his private army. And he's building it. And in the absence of that, I think that we're all going to stand up noisily enough and get rid of him. But that's optimistic.
Other question?
Yes.
Do you need the microphone?
Yes.
Yeah.
How can we rein in the shadow docket of the Supreme Court? How do we rein in the shadow docket of the Supreme Court?
Well, we can keep criticizing them and hope they're listening, but so far they haven't. I mean, the shadow docket consists mostly of decisions whether or not to take cases up on appeal, because most of their docket is discretionary, and deciding interim matters in cases that are coming up on appeal. What happens between the time a wrong is done and the time the Supreme Court decides it? Does the wrong allowed to continue, or do you stop it? And it's when we're dealing with civil rights and voting rights, it's those temporary decisions that really count more than the final ones do, because they're probably going to be in place for 2 or 3 years on average. And during that time, we either have or don't have a republic. So, Rick, you're right. It's a serious problem. And the Supreme Court has to convince itself to stop doing it. I have no solution for that one.
Another online question. Can you speak to money in elections and how that could be changed?
I can't. hear you say.
Money, can you speak to money in elections and how that could be changed?
We have what I think is an amusing constitutional doctrine, except for its consequences, which are not amusing, and that is that money is speech. That when you spend money for political purposes, that's the equivalent of the speech that the First Amendment protects. Sounds kind of silly, except that there are lots of things other than writing and speaking that really do qualify as speech. Marching, singing, holding posters. There are a lot of things. Those speech is an elastic concept. So while the money is speech doctrine sounds kind of silly, maybe it's not. What's silly and wrong and consequentially wrong is treating it, once you define it as speech, as therefore not subject to regulation. That's wrong. When I was in high school, we had campaigns for, I don't know, president of the senior class or something. And the county sheriff's son was in charge of one of the campaigns. And somehow he sneaked out the key to a county truck that had loudspeakers on. And I suppose during emergencies, they were supposed to, drive around and say, go into your basements or something. So Bobby Engel gets this truck, and one morning, he, and I'm not going to tell you who else was in it, driving around the New Brunswick, New Jersey high school was a full block. And so the truck drove around the block during class time, blasting a tough volume, vote for Engel and, well, where else he was running with.
Were you driving?
Pardon?
Were you driving?
Was I driving? No. No, I was too young to drive. Anyway, the New Brunswick police had a sense of humor, so they called the sheriff's office. And Bobby's father sent a bunch of sheriffs, sirens, lights flashed, and took us and put us in jail for a little while. Anyway, the point I'm making in a roundabout way is that speech can be controlled when it offends other people's rights or when it hurts other people's rights. You can't ride around the school with a truck blaring. You can't do that in a residential zone at 3 o'clock in the morning. You can't have music that's too loud in Bar Harbor. Maybe you can, but there are all kinds of ways in which constitutionally protected speech is examined for excess. And when an excess is bad enough to harm the rights of others, you can control it. I didn't make that up. Supreme Court never developed it. But that, I think, is the problem. Money is going to control elections so long as it's uncontrolled. It's wrong. The way to deal with it would be for Congress to pass a statute and then somebody who opposes it go to the courts and challenge it and see what happens. But that's not gonna happen soon. There's one state, I can't remember, maybe Wisconsin. I forget. Anybody know that there's litigation going on somewhere in the federal court over a limitation on money for state elections. Well, that doesn't, sorry.
Maybe just voted the $5,000.
Well, that's it, of course. I'm sorry. Thanks, Seth. It's good to have Seth. Yeah, I mean, that's gonna test that. But it's a real problem, and I think we're probably stuck with it for a long time.
I think.
Anything else?
Okay, so last question online. So would a constitutional amendment that creates a national standard for election districts, could that help in the longer term?
Start the question again. I didn't
Okay.
hear the first
Yeah.
part.
Okay, would a constitutional amendment that creates a national standard for election districts have hope for the longer term?
Yeah, that'd be great. I gotta tell you, the Supreme Court justices are not dopey people. None of them. May disagree with them, but they're no dopes. And the cream of every law school graduating class ends up sooner or later clerking there. And they have, among the 9 of them, 28 clerks, and the chief has 4, and the others have 3 apiece. So you've got there 37 of America's brightest lawyers, and they truly can't figure out a standard of how to do it. And really, the only way they can deal with that problem is by saying, this is too much in a particular case. Okay, we know that's too much. The next case, oh, this is all right. It's a little off. Okay, we've narrowed the gap. And it takes cases to build a line in the middle. It's a hard way of making decisions. It's almost like Justice Potter Stewart, who said, I don't know how to define pornography, but I know it when I see it. And it's that kind of approach that would have to be developed. Done.
Is that it? Yeah.
Done. Thank you very much. Okay.